The court ruled on Thursday that the federal government can block former government contractors from testifying about the torture of a post 9/11 detainee. The decision likely will make it harder for victims to essentially expose secret government misconduct for the future. And this particular individual here is the one who had appealed. This is his photo. His name is Abu Zabudai. Now, he was the first prisoner held by the CIA to undergo what at the time was euphemistically called enhanced interrogation. Let's go ahead and turn to what Nina Totenberg of NPR said. So essentially during one 20-day period, this man was waterboarded 83 times, 24 hours a day. And during that period, the suspected terrorist was also slammed against walls, put in a coffin-like box for hours at a time to stimulate live burial, and subjected to something the government called rectal rehydration. In the end, the two CIA contractors who supervised Zabudai's interrogation concluded that they had the wrong man. He was not a high-level Al-Qaeda operative, as the CIA had thought. Indeed, that they essentially terrorized this man and they had the wrong person. And I am without a doubt butchering his name, but can you believe this? And so now in trying to get that information, the Supreme Court is essentially saying, no, we are going to block it from public disclosure. But when we talk about public disclosure here, we need to bear in mind that essentially, as Nina Totenberg has written, all of this has been publicly documented by a lengthy Senate Intelligence Committee report, the European Court of Human Rights, widespread press reports, and disclosures by the two CIA contractors who supervised to torture. In fact, the CIA did allow the now former contractors to write and speak extensively and even testify in limited circumstances about the enhanced interrogation program. But when his lawyers subpoenaed them, the US government blocked the move by invoking the so-called state secrets privilege, a doctrine created by the Supreme Court in 1953 that allows the government to shield evidence harmful to national security. In this case, both the Trump and Biden administrations argued that even though the information about the torture programs is widely known, confirming the existence of CIA black sites. Yeah, this is it. In Poland, that essentially would jeopardize the US government's relationship with foreign intelligence services. So the Supreme Court ruled, as the majority said, in 7-2. It was a very fractured opinion, but essentially it had 4 different separate opinions on the majority side and a furious dissent. And I know that you know Sotomayor was likely a part of that dissent. But also we have to bear in mind that the outgoing Justice Breyer wrote the opinion. And so when he wrote the majority decision, he set out narrow grounds for siding with the government. But he added, we do not decide here whether a different request filed by might avoid the pitfalls of this particular case. Indeed, at oral argument, the government refused to say whether it would allow the appellant to now detained at Guantanamo Bay to testify himself about his interrogation. Only Chief Justice Roberts joined Breyer's opinion in its entirety. Justice Clarence Thomas agreed only on the end result and refuted the idea that judges should play any role in reviewing secret material. Kavanaugh and Barrett also filed a separate concurring opinion, and Kagan wrote that she largely agreed with Breyer's analysis. She would not have dismissed the case, but would have allowed the lower court to see if there were other ways of avoiding disclosure of secret material. Now, Gorsuch was pretty pissed. In an angry dissent joined by liberal Justice Sonia Sotomayor, he emphasized a long history of the government invoking national security to shroud major abuses. Here, the government really wants to avoid further embarrassment for past misdeeds, Gorsuch concluded. But as embarrassing as these facts may be, there is no state secret here. This court's duty is to the rule of law and the search for truth. We should not let shame obscure our vision. Now, this man at the center of Thursday's case, he has been in custody now for nearly 20 years. Nearly 20 years. And we have to bear in mind that he's just looking for information that's been provided everywhere else to be provided directly from the government itself. Now, since 2006, he's been at the US base at Guantanamo Bay in Cuba, and he remains there despite having been cleared for release. There are just 39 prisoners left at Guantanamo, where the price tag is $13 million a year for each prisoner. 20 have been cleared for release, 12 have been charged in 9/11 related cases, and the remainder have not been charged but are considered too dangerous to release. This seems like, it just seems like it makes this look really bad. The fact is that the Supreme Court couldn't even get it together to acknowledge the fact that this information is out there already. It's been provided by many different sources. There have been books written about it. There have been movies on it, but the government is still trying to claim that there are state secrets. Kyla?
I think it's really important to contextualize this case with recent national events. The United States government has taken the moral high ground in the Ukrainian-Russian war and has continually condemned Russia for practices such as the military imperialism and torture of prisoners. Yet these are the same tactics the US continues to take part in and cover up. Hypocrisy aside, it also raises the question of whose torture do they deem acceptable? And no surprise, it's the continued torture and subjugation of Black and brown people. I just want to be clear that both Russia and the United States governments are rife with corruption and federally and internationally approved violence. I condemn both of them for it, and I hope that the victims of each nation will receive justice for their treatment. I hope that the two justices who ruled against the trying to cover all this up continue to advocate for changes within our justice system, because again, this is completely deplorable. I am definitely ashamed that our country has taken this stance, and my heart and condolences just go out to that man who was wrongly convicted and tortured.
Yeah, well, not even convicted. He's just being held there and tortured. And the fact that they've identified that he wasn't essentially a spy in any way, and these things that they did to him, that has to change your entire fabric and makeup as an individual. He was tortured for hours and hours upon a day. And the fact that all of the information's out there and it's been provided by numerous sources and is available from numerous sources, yet still the government is arguing, nope, state secrets. And also let's bear in mind that Gorsuch, conservative Gorsuch, is on the side of saying, no, this ain't right. Come on, It's like the moral compass. Where is it when it comes to the court? It really speaks to our level of willingness to conceal our misdeeds and our misconduct when it comes to engaging with individuals who are foreign nationals. It just, wow, it speaks volumes.